when you're involved in a legal dispute, and very often in an employment, sometimes, and I'll just take the Workplace Relations Commission or Labour Court as an example. Sometimes I'm acting for the employer, sometimes I'm acting for the employee. And when you look at the statements then that both parties make, there could be quite a bit of emails, correspondence and notes and so on, and quite a lot of contention between the parties as to what actually happened, what the facts were. And very often that's a difficult case because it's going to be difficult to conclusively prove your client's version of events. It can be difficult to prove your client's version of events because it's met by a massive body of contradiction from the other side. And likewise, the other side will have the same problem in relation to my client's position. There will be a straightforward conflict of evidence between the parties, and there'll be all sorts of assertions and statements made and emails and letters introduced to win the day and show that one party's version of events is more plausible and more readily reliable and credible than the other. So that's one big messy case, and it can go either way, and it takes work, it takes time, and it does require a good bit of persuasion of the decision maker. And whether that decision maker is an adjudication officer at a WRC hearing or the Labour Court, the three persons on the Labour Court, it can be difficult. But sometimes, very often, and these are my favourite type of case, and for obvious reasons, sometimes, and I'm just waiting here, actually I'm watching for the train to come. The train coming pretty shortly there. But sometimes these are the cases that you love, actually. Sometimes you have a case where you have what I call a money shot. So if you have any interest in boxing, whether it's amateur boxing, but particularly professional boxing. In professional boxing, if a professional boxer has a glass jaw, well, he's going to be in trouble. He's going to be in trouble, and they're going to get it hard to make a living. And sometimes he might be a great boxer, not have a glass jaw, but doesn't have a money shot, doesn't have a punch that'll put the other guy down. It's the same in a WRC hearing or a Labour Court hearing, or indeed any dispute, any litigation, that it may well happen that you have a money shot. And if you have a money shot, you're going to basically hang your entire case on the money shot. And sometimes you can be lucky enough to have one, and sometimes you don't have one, and that's just that. You're going to have the big amorphous blob of a mess of contentions and counter contentions and assertions and counter assertions. One side is against the other. But when you have a money shot, it's great. And a money shot could be an email or a letter, for example, which gives the lie to the case that's being brought. So there may well be a case being brought, for example, about, let's just say for the sake of argument, constructive dismissal. And a constructive dismissal case involves the employee proving that they had no choice but to leave the job because of the unreasonable conduct of the employer, and that the employer breached the contract of employment. But basically you're saying that you're a reasonable person, you did everything possible to resolve the issue, resolve the dispute, and due to the completely unreasonable conduct and behaviour of the employer, you had as a last resort to leave the job, and now you're entitled to win your claim for constructive dismissal. But what if there is an email or a letter which gives the lie to that case that's being argued? Such a letter could be, for example, one which indicates think I hear the old train coming there now. That's the money shot in this video. But as I was saying, there may well be an email or a conversation. Conversation's harder to prove, quite frankly, but there may well be an email or a letter from the employee to the employer, which basically gives the lie to that case that's being made for constructive dismissal. And an example of such a case would be, for example, where an employee might have written to the employer and said that they really enjoyed working in the place and thanked the employer for all of their assistance and so on, and were now tendering their resignation. That obviously gives the lie to the proof that's required that the person had no choice but to leave, and what compelled or forced them to leave the job was the unreasonable conduct of the employer. Clearly there's a contradiction at work. If, for example, on the one hand you're saying you had no choice but to leave because of the unreasonable conduct of the employer and the employer's breach of the contract of employment, and on the other hand you've left behind a smoking gun, a letter or an email perhaps, thanking the employer for their assistance and thanking the employer for the experience. That's a fairly graphic, straightforward contradiction. It's not too often you'll get those, but you will get them, quite frankly. You will get them. And so if an employee comes to me and I look at the correspondence and they're bringing a claim for constructive dismissal, I'm going to have to tell them in fairly plain graphic language. I'm going to have to come directly to the point and tell them that you're going to have a very hard time winning that case for constructive dismissal in this situation. Similarly, there's other types of emails or letters that might be sent in by, for example, an employee to an employer, which would make it very, very difficult to win the case. And it works both ways. Sometimes an employer will leave hostage to fortune or send an email or send a letter that's going to make it very difficult. Make it very, very difficult for the employer to successfully defend the case. But the key is, sometimes you come across a case where you've got a money shot, and those cases you look forward to, and you can't wait to unveil your money shot, whether it's an email or a letter or something else, some other piece of evidence. And similarly, the opposite of that is one where it's a big amorphous blob of a swearing match, one side swearing blind to one set of facts and the other side swearing blind to something else, and it's a mess. You're putting the thing in the hands of the adjudicator and you're asking the adjudicator to find which version of events is the more realistic, which is the more plausible, etc. But so be careful if you're an employer or an employee that you don't actually leave hostages to fortune or money shots, because if you do, you're going to have a very difficult time winning your case, and you're going to have a lad like me chomping at the bit to get the money shot out into the open early and often, quite frankly, especially if it goes to the very heart of the case that's been brought, and which undermines the claim that's being brought. And it does happen. Those are the sort of cases I like, especially at the WRC, Labour Court or wherever. Anyway, I'm just on the canal here today. I think it's the 26th or 7th or 8th of June 2025. Nice day, very warm and close. It's a Thursday. And today now I'm on a different side of the canal. I'm usually over the far side there, but today I'm on a different side, just for the giggles. Hope you find the video useful. If you do, I would appreciate if you hit the thumbs up button down below. Thanks very much.